आप देख लो। क्या करूँ? मैं अपनी फोटो देखना चाहता हूँ। ठीक है, ऐसे आ गया ना इंटर मेरा, बस ऐसे ही आना चाहिए। अब इसमें वो कीजिए आपको। हाँ ठीक है, ठीक है, कीजिए, क्लिक कीजिए, डाउनलोड।
Arun sir, good evening.
Welcome, ma'am.
Good evening, sir.
ठीक हो?
हाँ जी सर,
All the best. Good luck.
थैंक यू सर।
जसवाल साहब नमस्कार। चंचल जी
Welcome, welcome. Sir, welcome.
गुड इवनिंग
नमस्कार।
सर।
Evening, sir.
आज आपको बहुत गालियां निकाली है हमने।
उम्र बड़ी होती है, रीजन
चंचल को फंसा दिया मेरे को और क्या।
चंचल मत करो ऐसा सर के साथ। डिसीजन हम लोग 10 मिनट्स में बिगिन होंगे।
हाँ जब मर्जी हम आ गए हैं भाई टाइम पर।
थैंक यू सर।
ओ मीनू मीनू तो पाँच आपने तो बड़े बड़े स्पीकर इकट्ठे कर लिए पूरे थ्रू आउट इंडिया।
जी बिल्कुल।
सर शुरुआत हमने आपसे की है सर।
मेरे को तो मेरे तो नहीं बिल्कुल। वो मेरा 30th वाला काट देना क्योंकि मेरी इंस्पेक्शन है उस दिन यहाँ पे।
श्योर सर, सर ठीक है सर।
30th का मतलब कि कोई अरेंजमेंट कर लेना बिकॉज आई हैव यूजीसी इंस्पेक्शन ऑन दैट डे।
जी सर।
आई विल बी बिजी विद दैट।
लिटिल लॉर्डशिप ज्वाइन कर रहे हैं।
जी मैम।
हाँ, मैम। हाँ, ठीक है, ठीक। ये लाइट है काफी। ओके बच्चे।
Ma'am, his lordship will join at sharply at 4.
Okay. Once he joins, we'll start.
We'll start.
Good evening, sir.
Good evening, sir. Welcome to the program, inaugural session.
Thank you, sir. Thank you.
Sir, we will start at 4 sharply. We are waiting for his lordship to join, chief guest. This is we are Ramasubramanian.
Good evening. To remove the raise your hands, any option is there, sir?
Yes, sir.
How do I remove the raise your hands?
This is not clear actually.
That is in participant list.
You press it on the same icon of the hand, it will remove.
Okay.
हाँ जी आपको ऊपर आना पड़ेगा
I request everyone to please turn on the camera. The participants will start in another 5 minutes. Our chief guest is about to join.
The voice is not audible.
I thought it was represented by. To see where she is. I thought that was Rahul's suggestion. No, he is not able to do anything. I think he is not aware of what to do because now I have opened. I don't know whether I'm visible or
Soon
not.
we'll start. We are waiting for our chief guest to join.
No, I clicked
Starting
on it.
another
I
5 minutes.
clicked on it and it says, please fill up mail, host email ID. He is not giving me a link where without an ID, email ID. Now I put in my email ID. Then I am allowed as a participant, not as a this thing. I think he doesn't know what to do. Oh, see, it should have been done earlier. No, because now it's 15 minutes past. Yeah. I don't see the chief justice also. Oh, he's not going to come. Okay. Oh, okay. So.
Sir, all due to some technical error, our chief guest is not able to join, so you have to wait for another 2 or 3 minutes. Sorry for the delay.
Are you able to see me? No, huh? No, it is again don't, I think participants list. I don't know whether they're able to, yes, they are able to see me. Yes. My name is shown as Hemraj. That's the problem. Okay. Okay.
Just everyone, please turn on the camera. With the permission of the chair, sir, shall we start?
Yes, yes.
Thank you, sir. A very good evening to honorable dignitaries, distinguished guests, ladies and gentlemen, and dear participants. It gives me immense pleasure to extend you all a very warm welcome on behalf of Himachal Pradesh National Law University, Shimla. I, Dr. Deepika Gautam, Assistant Professor of Management, feel privileged to call upon our Honorable Vice Chancellor, Professor Nishtha Jaswal, who has been the driving force bringing out the new face of the institution into the society. With over 3 decades of teaching and research experience, Professor Nishtha Jaswal specializes in constitutional law, administrative law, human rights, and environmental law. She has over 50 research papers and more than 6 books to her credit. She was also a gold medalist during her college years. She is a recipient of Visiting Professorship Award from the British Academy in 1992. She has served various roles through the course of her prolific career, including as a member of Chandigarh State Legal Services
I think
Authority.
we must proceed further. We are already getting late.
Okay, ma'am. So now I request you, ma'am, to please formally welcome the dignitaries and participants.
Thank you, Deepika. At the very outset, I really apologize from Honorable Lordship as well as the participants, and I must inform the participants that delay was there because of the technical issue, and that too on the part of the university. I really apologize, Lordship. It's a matter of great pleasure and privilege to welcome Honorable Mr. Justice V. Ramasubramanian, Judge Supreme Court of India, and Masiha for HPNLU Shimla. ध्रुव तारा है ज्ञान के मानव प्रेम समाया है इनके संस्कारों में ध्रुव तारा है ज्ञान के मानव प्रेम समाया है इनके संस्कारों में ऐसे हैं ये न्यायाधीश समाये हैं हमारे हृदयों और विचारों में Lordship, I translate because I write poetry in Hindi only. Lordship is a pole star having the shine of knowledge. His values have imbibed in him the love for mankind. Honorable Lordship, you always remain in our hearts and minds. I welcome you once again, Lordship, from the deepest core of my heart. I also welcome Professor Paramjit S. Jaswal, Vice Chancellor, SRM University. He was formerly Vice Chancellor of RGNLU, Patiala, Punjab. दिग्गज पधारे हैं आज तुम्हें संबोधन को दिग्गज पधारे हैं आज तुम्हें संबोधन को संभाल के रखना उनके बहुमूल्य शब्दों को A great personality is here to address you, preserve his precious words. I also welcome all the participants from throughout the country. Had there been not COVID times, we would have met personally. सुशोभित हुआ HPNLU तुम्हारे भाग लेने से सुशोभित हुआ HPNLU तुम्हारे भाग लेने से याद रखना ज्ञान बढ़ता है सदा देने से You have adorned our HPNLU today. Please always remember that knowledge increases by sharing. I welcome all of you once again and coming to the theme. we are going to have this capacity building program on comparative public law and Hindu philosophy. The moment we talk about comparison, our Vedic times, Vedic ages, our Vedic literature, Vedas, if I try to compare being a proud Indian, I find very difficult. But still, I'll just touch
When I tell that
Roman law, the ancient times,
there
which
has
was
to be
developed, Greek
reason.
law. Roman law is the legal system of ancient Rome, including the legal development spanning over
Correct.
thousands
Yeah.
of years of
30,
jurisprudence. From the 12 tables, that is 449 BC. Please
I will not be
unmute.
able to do
All the
anything when I
participants, please unmute. To the Corpus Juris Civilis, that is 529 AD, ordered by Eastern Roman Emperor Justinian I. Even this Roman law is prevalent. We follow in our civil laws, mostly in most of the legal systems in the world. Greek law, we don't find any systematic collection. Whatever notions we find, these are derived from the Homeric poems. And the earliest shown Greek laws date back to the Code of Laws by Draco and Solon, who both had an immense impact on early Greek law. Incidental illustrations of the Athenian law are found in the laws of Plato, was criticized by Aristotle, and the treatise on the constitution of Athens includes an account of the jurisdiction of the various public officials and of the mechanics of the law courts. Now coming to Indian Hindu philosophy and this law, dharma is the Indian version of natural law. How Indians perceived it in ancient society. Dharma in literal sense means something which sustains or upholds. Now it is derived from the Sanskrit word dri. Dharma is equivalent to the Greek word ethos. In the modern times, we may have misnotions that we take dharma as a religion, while dharma includes religious rights, rules of conduct, and duties. And here we are not talking about the religious rights. As Gemini said, dharma is founded on the revelation which is conducive to the welfare of the society, obtained by great Vedas. I'm reminded of jurist Duguid. Said the only right which any man can possess is the right to do his duty. This may be in a direct contrast with the present times where we are mainly concerned with our rights. But fortunate are we that in our constitution, by 42nd Amendment Act 1976, which is amended by 86th Amendment Act 2002, Part 4A, that is fundamental duties, was added. So, and I believe in Hoffardian concept of that every right has a correlative duty. The dharma originated from Vedas, and we find a reference in Brihad Aranyaka Upanishad when we say punyo ve punyana karmana bhavati papa papaneti, which means everyone becomes good by good deeds and bad by bad deeds. And here we can refer to the English proverb also, as you sow, so shall you reap. Manusmriti Shloka also states that Veda Akhil Dharma Moolam, that is, all Vedas are the root from where deeds or karmas originate. Even Purva Mimamsa Shastra also states that God gives order to all human beings that whatever deeds are discharged by human beings, according to Vedas, these are called dharmas, and which are not inspired by God in Vedas, and which is not to be followed by human beings, we call it as adharma or irreligious deeds or sins. There are certain signs of dharmas or pious deeds. Firstly, to understand, and I'm just referring to some, to understand, obey the orders of Almighty God. Now we adopt this in public law when we talk about that the laws have to be obeyed. The ruler has to be obeyed. Duties towards the nation. To realize all living beings like one's own soul. Now, this is the background of what we today call as principle of equality. or we talk about and the present innovations by different courts throughout the world, like Wednesbury principle, or we talk about any other principle. And then also we talk about the issue of that dharma does not include blind faith, bad traditions, selfishness, false convictions. And dharma talks about the spiritualism also. Spiritualism in the sense that unless and until we discharge our moral duties, we cannot have happy and long life. I'm immediately reminded of that carrying the Indian culture, our Supreme Court of India. Now, if interpretation of Article 21, that is right to life, was widened as so as to include the right to live with human dignity, I think we had this background in our mind. And today we do talk about, when here we say long, happy life, even right to life includes right to health, right to well-being. And when we study all the four Vedas, we find reference to permanent peace, salvation. My emphasis here is promoting universal brotherhood. Now, our Vedic literature talks about Vasudhaiva Kutumbakam. The whole earth is our home. Now, here I would like to make a reference to our constitution, the Centum Sanctorum. The preamble itself refers to fraternity, which means a brotherhood. And even Samaveda Mantra 50 states that every human being must listen to Vedic knowledge from learned Acharya. And Lordship, this is in the background. If we are conducting this capacity building program on comparative Pacific law and Hindu philosophy, I find a story in the Vedas where one father asked his son to bring a fruit for him. So the son broke the fruit from the tree, broke it, and father asked, "What did you see?" He said, "Broken fruit with seeds." Father asked, "What else did you see?" He said, "Nothing." Father informed him that what you do not perceive is a sense, tattva and sattva. And that is why the father further advised the son that in that a sense is the self of all. And this is the basic principle of democracy, equality, fraternity, or when we talk about rule of law or anti-arbitrariness, that we don't have to concentrate on I, but on we. Our constitution also begins with we, the people of India. And that we need to recognize the predominance of self of every person so as to reach to the collective good of masses. In 18 major Puranas, we find a tripartite division of gunas. Sattva, that is purity, tamas, that is impurity or ignorance, and rajas, that is passion. And further, I would just like to refer to Bhagavad Gita also, which talks about three ways of approaching the world: the mind, to emotions, to actions. And these are tied with three yogas: duty, insight, and devotion. I think I'm not wrong if I say in any period of time, the different forms of state, maybe legislature, maybe executive, maybe judiciary, they are bound by such approaches. And when we talk about any action where we talk about principle of that no bias should be there, then we do apply these principles. And that is why Gita also talks about three main obstacles or hindrances. One is when we are too attached or too happy. And we are too attached not only with something wrong, but even with righteousness. And we are attached to passion and activity to the extreme. Or we are just lazy, we shirk work, we don't want to work hard. That is, as you say, sangharsh or struggle and destiny. So for achieving any aim, these have to be followed. We have to have practical approach. Even when we interpret the laws, we generally follow the golden rule where we have little liberal interpretation. And at the same time, I would just like to refer to another very important shloka, that is Yasman udvijate loko lokan udvijate chaya harsham harsh bhayo udveg mukto ya sacha me priya. Now this Gita, Shri Krishna telling the Arjun, but it has a meaning for all of us, for those who are governing also, for good governance. Those who are not a source of annoyance to anyone and who in turn are not agitated by anyone, who are equal in pleasure and pain and free from fear and anxiety, such devotees of mine are very dear to me. I'm referring to rule of God, rule of law. Another, after dharma, we need to talk about nyaya also. Nyaya in the Sanskrit is the rule of method, where we talk about analysis of logic and epistemology. We may literally translate it as a concept of justice to relieve human beings from all kinds of sufferings. But we are human beings and human errors can be there. We commonly say to err is human. So I need to talk about danda also. Danda word is derived from dam and dand, which means to tame, to subdue, to conquer, to restrain. And the moment we use these terms, that means we are talking about reformation. And according to Manu, it is only the king who can protect the entire mankind. And for this protection, he uses dand as an instrument. And even people can collectively take action against the king if the king does not follow his dharma. And finally, I'll conclude. I'm a poet by heart. Whatever I could not say in my words, this is in my poetry, but it will be translated in English for Honorable Lordship. भारत तो शिक्षा गुरु था संपूर्ण भूमंडल पे, भारत तो शिक्षा गुरु था संपूर्ण भूमंडल पे, मन में समाया तो नात्मक अध्ययन कर ले सार्वजनिक कानून पे. India was a global teacher on this earth. In the present times, we availed this opportunity to do comparative study, especially in the context of Hindu philosophy. कानून धर्म न्याय और दंड से नियमबद्ध था. कानून धर्म न्याय और दंड से नियमबद्ध था. राज शक्ति पर राज धर्म का नियंत्रण था. During the Vedic times, law comprised dharma, nyaya, and danda. That is punishment. Rules prescribing duties for kings controlled the power of the rulers. हिंसा का राज प्रशासन में कहीं व्यापार न था. हिंसा का राज प्रशासन में कहीं व्यापार न था. दंड सुधार की परिभाषा से अपरिचित न था. Violence has no business in the administration. Punishment had inbuilt approach of reformation. ईश्वर का साम्राज्य एवं कानून सर्वोपरि था. ईश्वर का साम्राज्य एवं कानून सर्वोपरि था. सत्व तमस रजस का दर्शन मार्गदर्शक था. There was rule of God and law. The philosophy of purity, impurity and passion was the guiding force. वेदों की धरती पे मंत्र गूंजते थे. वेदों की धरती पे मंत्र गूंजते थे. आत्मा के परमात्मा से मिलन के विचार ही सूझते थे. The echo of Vedic mantras could be heard on this earth. Union of soul with supreme soul, that is the Almighty, was always in our minds. उसी सभ्यता और संस्कृति को इतिहास गुजार कर लाए हैं. उसी सभ्यता और संस्कृति को इतिहास गुजार के लाए हैं. फिर अपने प्रशासनिक नियमों और कानून को दास्ता से नहीं निकाल पाए हैं. We try to carry our civilization and culture in our voyage through history, but unfortunately, we have not been able to liberate our laws relating to administration and governance from the chains of slavery. And finally, I pray to God, हे परमपिता, बना सशक्त स्वतंत्र हो विचारों में. हे परमपिता, बना सशक्त स्वतंत्र हो विचारों में. सीख लें विश्व से और नाम हो सितारों में. सीख लें विश्व से और नाम हो सितारों में. O Supreme Father, empower us with free and independent thinking. At the same time, bestow wisdom upon us to learn from the whole world and shine like a star in the sky. Thank you. Sarve Bhavantu Sukhina.
Thank you, ma'am. Thank you so much. Your words are really a source of encouragement to all of us. Thank you, ma'am. Now, I request Dr. Chanchal Kumar Singh, Director, Center for Comparative Public Law, to kindly introduce to the participants about the 2 weeks capacity building program on comparative public law and Hindu philosophy. Over to you, sir, please.
Dr. Deepika, Honorable Chief Guest, Honorable Mr. Justice V.R. Ramasubramanian, Guest of Honor, Honorable Vice Chancellor, Professor Paramjit Singh Jaswal, Honorable Vice Chancellor HPNLU Shimla, and dear participants. This program is conceived with a purpose that what law, legal categories, legal principles can be discovered, developed, refined based on Indian culture, Indian history, and Indian ancient literature. India had a well-developed legal system, legal process, but in course of time after colonialism, we received law, or rather it was imposed progressively over 200 years on India. Now, there is a great difference between a Western system of thought, knowledge, or theory of knowledge, that law or legal categories are developed within the cage or perimeter of state power, whatever a form that a state might have existed. In India, law and legal categories enjoyed in ancient time until medieval time independent autonomous status from the state in many manners. Law antedates or predates state and state authority. So this program and here at our HPNLU Shimla, we are trying to learn, develop how we can learn and what things in legal system or rules of or principles can be developed from Hindu system of thought as well as literature. I would like to quote one of the words from Manu Smriti, which says there are 4 sources of law. This is chapter 2, verse 6 of translated the book translated by G. Bueller, which says that the Vedas is the first source of law. The second source is virtuous conduct of those who knows the Vedas. The third source is customs, and fourth source is self-satisfaction of the individual. We look at this arrangement of sources, state is nowhere referred. All sources of law are internal to the individual and community. This is a paradigm shift from Western thinking, which cannot think of law or legal process outside the state and state authority. I would like to quote what has happened in last 200 years. One of the paper published in Shimla Law Review, published by HPNLU Shimla, it says that any particular social order in a community at a given period of history is the byproduct of psychic social framework through which its members are connected and share the bond with each other. This framework is supplied by the theories of knowledge that the intellectuals of that society and by that which its forefathers have developed. When that framework is imposed from outside, received imposed laws such as common law country on a people, the individuals having an artificial capacity to connect to the framework loses forever the natural capacity to connect with other members of the community and can only connect to the very framework itself. This simply can explain why and how, for example, criminal law. Every few years, criminal law or penal laws are improvised through amendments, but crime rates keep on increasing. There is some problem or some fundamental problem with the very idea of law we have received, the idea, the conception of law we have received from. This program, I hope, will further give some impetus or some help for us to learn from our past. Thank you. Over to you, Dr. Deepika.
Thank you so much, sir. Now, dear participants, the guest of honor for the inaugural session of this 2-week capacity building program 2021 is Professor Dr. Paramjit S. Jaswal, Honorable Vice Chancellor, SRM University, Delhi NCR, Sonipat, Haryana. Sir needs no introduction, for he is a legend in the field of legal academia, Sir's academic acumen stands reflected in the distinguished positions he has held thus far.
Deepika,
Sir is the former Honorable Vice Chancellor of Rajiv Gandhi National University of Law, Patiala, and of Hidayatullah National Law University, Raipur, Chhattisgarh. Sir has been former Chairman, Department of Law, Punjab University, Chandigarh, and former Director, University Institute of Legal Studies, Punjab University, Chandigarh.
I think
He has been part of several academic bodies of various legal research across the nation. Apart from holding experience of teaching and research of more than 40 years, Sir is
Deepika,
also a renowned author, for he has to his credit numerous books and research papers published in various journals of national and international repute. Sir has been awarded British Fellowship Award for doing postdoctoral research in the Department of Law from School of Oriental and African Studies, University of London. Sir has also been awarded with the Career Award for Young Talented Teachers by the UGC and has also been awarded Bharat Jyoti Award and is a recipient of Eminent Great Personality of India awarded by the Shaheed Memorial Seva Society, Ludhiana. Sir was also awarded with the DAV Educational Managing Committee conferred Vishisht Samman and Award of Excellence for Outstanding Contribution by Maharaja Agrasen University. Sir is Shane-e-Hind Awardee and a Fulbright
Deepika.
Fellowship holder by United States India Educational Foundation, New Delhi. So now I request you, sir, to kindly address the virtual gathering with your kind words of wisdom. Sir, please.
Thank you very much, Deepika. My Lord Honorable Justice V.R. Ramasubramanian ji, Honorable Vice Chancellor Professor Nishtha Jaswal, Dr. Chanchal, other faculty members, and dear colleagues. I am in a real dilemma to speak in the presence of Honorable Mr. Justice Ramasubramanian ji, who is so well read, particularly when we talk about Hindu philosophy. Of course, being a judge of the Supreme Court of India, he is a master of laws, but I have had the occasion to visit his personal library, which is so rich with the Hindu philosophy books. I'm finding it difficult to speak on the topic. Be that as it may, Dr. Chanchal, who is the director of the center, when forced me to speak on the topic, I couldn't say no. If I dissect the anatomy of the topic, I find three words: comparative, public law, and Hindu philosophy. And it is very difficult to separate them from each other. And at the same time, it is also very difficult to speak on all the three aspects of the topic, because the discourse will become very lengthy, and we would like to actually hear our chief guest, Honorable Mr. Justice V.R. Ramasubramanian ji. So therefore, what I am going to say is, I will speak something about the public law and try to correlate it, how it has evolved to the present times. The public law is a special branch of a jurisprudence. In the Middle Age, it was also called the fundamental law, which was different from the civil law or the ordinary law. The difference between the ordinary law and the fundamental law is that ordinary law binds the individuals. The civil law deals mostly with the individuals, person versus person. When we talk about the fundamental law, it deals with the king and his officers, or the governing authorities. The distinction has been very nicely given by Bracton. He says the power of law, when it is vested, or power of making the law is vested in the king, then that outcome of a law is called the ordinary law. And the law which makes the king, a law that makes the sovereign, is called the fundamental law. Today, in the modern times, the modern name of this fundamental law is nothing but, in short, the public law. Public law, if we study the annals of history or its growth, it has given rise to the modern concept of the state. With the passage of time, economic, social, political, and technological development have brought mutation change into the character of the fundamental law. We in India, in the modern days, or just at the time of independence, started following the common law. Before that, when we were under the British rule, we were governed by the British law. And if we study the British constitutional practice in early days, then the rule of ordinary law was followed in England too. Without going to the early history, I just take the example of from Magna Carta to of 1215 to the Bill of Rights of 1689. Following this, the modern English constitutional law, or the constitution, was shaped. It recognized the law that is made by the parliament, and the parliamentary supremacy came to exist. Parallelly, we saw in Europe the French Revolution, 1789 to 1799, and then back again, if we come to England, the concept which was given the formulation by Dicey in 1885, the concept of rule of law, that emerged, and that is relevant even today in the modern laws also. When we talk about the rule of law has three formulations as given by Dicey. The first one, the universal subjection to the ordinary law as applied by the ordinary courts. That means if even the king is also under the law and the god, the ordinary court should administer and govern all people, and that law should be administered by the ordinary courts, and the justice should be provided by them. In fact, Dicey was totally opposed to the concept of the evolution of the Conseil d'État in France. In fact, the growth of administrative law, which was taking place, rather it was in the advanced stage with the tribunalization in French system. He was thinking that it is against the rule of law because there were separate tribunals to deal with the officials of the government by the state. The second part, which has, as Professor Nishtha Jaswal was speaking in her welcome address, is very important formulation of the rule of law, that is the absence of wide discretionary powers. This concept of absence of wide discretionary power, which is so deeply ingrained into the Constitution of India in various provisions of the Constitution, particularly Article 14 of the Constitution, which talks about equality before law and the equal protection of laws, is nothing but culmination of that part of the public law, which was expounded in much more detail in the end of the 19th century. The third formulation was particularly relevant to England. England, as I said in the beginning, was having by that time the parliamentary supremacy. Parliament could make or unmake anything. It is said that it can do anything. Only thing it cannot do is it can't make a man a woman and a woman a man. That is considered the parliamentary supremacy. But with the passage of time, the things have changed. At that point of time, the Dicey was of the opinion that when we confuse fundamental rights with fundamental law of the land, he said the fundamental rights are not the product of the Constitution. They are the product of the convention. The acts which are passed by the British Parliament. He did not give the supremacy to the Constitution for the emanation of that. For example, when we talk about different kinds of writs, the most important writ which comes to our mind for the protection of life and liberty, the writ of habeas corpus. Now, it came into 17th century from the British Parliament. So that is how he was having, because Dicey, we must understand, was not a lawyer. He was a historian. He was with the history background. So what we find that with the evolution of this concept, or the formulation of the concept of the rule of law, the so-called fundamental law, which we today call as the basis of the public law, that almost disappeared. The concept of public law actually developed in European countries. It has a European origin, and it is a Western invention. The origin of public law can be traced to the medieval period, and the medieval period in the history we generally call about from 5th century to the 15th century. And it is also considered to be the expression of the natural law. When this public law was being developed, and as I mentioned earlier, in France particularly, the concept of droit administrative, that the tribunalization, the power or the forum of dealing with the government or the state with the public official, that was not through the ordinary courts, that was by the separate court, the separate tribunal, that had already developed to a great extent. But in order to understand the formulation of public law, one must understand the evolution and the functions of the state. Public law, when we are talking about the evolution of the state is clearly associated with the concept of sovereignty. And in the modern sense, the most important function which the state has acquired is the welfare of the people. State in general, when we talk in a general sense, has three concepts or three components. One is every state has a defined territory. The second is it has the authority to rule, ruling authority. It has, that is what in Austinian sense, the command of the sovereign when we talk about. And the third, the authority to rule is over the people. So people must be there. These three components of the state we must understand to further understand the concept of the public law. The authority of the state was considered as absolute, and the state being itself the source of law, no fundamental law that could bind the state could exist. But the question is, can the state make a law which is absolute, or can the state make a law which is arbitrary? The answer is obviously no. And that is what we see when we compare with here at this very stage with the Hindu philosophy. If we study the ancient history, Dr. Chanchal also, Professor Nishtha Jaswal also in their introductory remark did make reference to various parts of the Vedas and Smritis and Manusmriti, etc. It is categorically mentioned the essence of our dharma was to provide justice. And if you talk about justice in the sense in which our Hindu philosophy talks about or speaks about justice is, then in that case, state cannot make a law which is absolute in terms or which is arbitrary. And from there arose the concept of the Constitution in the written form. We see the parallel development in America and in other countries also in the 17th and 18th century and in the beginning of the 19th century. The concept of Constitution as a fundamental law came, wherein almost all the constitutions of the world did incorporate into it the concept of non-arbitrariness or the due process clause, or what we call the justness, fairness, and the reasonableness of the operation of the law. Constitution also contained in these things in different provision, and the Constitution also contains many unwritten provisions which lead to from constitution to constitutional law. Constitution is a basic framework of certain provisions which are nothing but fundamental laws. But when it comes to the application of those provisions, keeping in mind the function of the state and the welfare of the state, then the constitutional law comes into operation, wherein the contribution is by the legislature, by making the law, or many a times, like a country like India, we are great. We are so lucky to have our Supreme Court, which interpret the constitution in such a manner to look after the welfare of the people and develop the new constitutional law. The state, there is an interplay. If you draw a triangle, you can put the state on the top. One part deals with the constitution, which represents the will of the people. The other part deals with the sovereignty. The constitution does not allow to denude the authority of the state. The constitution does not allow or to erode the welfare or justice to the people. And that is how the triangle between state, sovereignty, and the constitution can be drawn. And there is an interplay between these three. The state is the legal order. I call it the state as a legal order. The constitution is the basic norm of the legal order, and sovereignty is the totality of the norms in the autonomous legal order. When we talk about the constitution protecting the will of the people, that is nothing but whatever recently Supreme Court in the various judgment has been talking about constitutional morality in deciding various cases. Now, this constitutional morality is nothing but the value of the constitution, which they translate into the constitutional law. And that is why it is also accepted by the people, because it is always, constitutional morality is always for the welfare of the people. It is never against the welfare of the people. It tries to bring in the justice in the justice delivery system. In the modern sense, this constitutional law, this evolving constitutional law, which has the focus of certain normative values or the legal order or the will of the people, is also given the name in the modern sense as a part of the public law in the form of the fundamental law. So constitution is always dynamic, it is always emerging, and it gives rise to new principles from time to time, depending upon the demands of the society. And the most important feature of the modern constitution, particularly when we talk about the Indian constitution, is that it has the constituent power. Constituent power has to be distinguished from the legislative power. Legislative power is with the legislature. The constituent power can also be exercised by the legislature. It is exercised in many a time by the legislature, but it is by amendment of the constitution. Like we have that example of the 25th amendment or 42nd amendment. Professor Nishtha Jaswal talked about in introduction of part 4A of the constitution. That is the constituent power to change the constitution. And many a times, the judiciary by judicial interpretation adds value to the existence of the constitution to bring constitutionalism. So when the constitutional norms and developed into the constitutional law bring about a parity or harmonious blend with the rule of law as against a rule by law, there arises the constitutionalism. And the basic purpose of the public law is to promote the constitutionalism in any state. That is the interplay which I think should be there between public law and the constitutionalism. So the constitution today we can say is a fundamental law. Secondly, judiciary interprets and enforces this fundamental law, and the most important, the third component is the judiciary claims to be the guardian of the Constitution through the potent weapon of judicial review, which is vested with the higher judiciary, not with every courts. This is with the high courts and the Supreme Court. Thus, the public law helps in maintaining this constitutionalism. The example of Marbury versus Madison, the passage which is quoted and re-quoted by all the research scholars of Chief Justice Marshall in this case of 1803, with regard to the judicial review and the power of the Supreme Court to interpret the Constitution and protect the constitutionalism, is nothing but a statement of public law. For realizing the function of the modern Constitution, three principles must be accepted. One, the constitutional supremacy. We call it a fundamental law or don't call it a fundamental law, but we had to accept constitutional supremacy as the part of the public law. Secondly, the Constitution as fundamental law of the land, because no law can exist which is contrary to the Constitution, so it becomes the fundamental law of the land, and judiciary, as I said, act as a guardian of the Constitution. Modern state, the function of the state have increased. Today, not only the state is concerned with the public order or security of the country or to protect its sovereignty from the external aggression, it also provides for number of social, economic, cultural, religious protection to the people who are governed under that public law. Thus, the emergence of various branches of law today. I do not have the time to go on, and we would like to listen to Honorable Mr. Justice V. Ramasubramanian ji, but I just take a minute to say administrative law. Administrative law is nothing but a culmination of the putting the constitutional law into action. So the administrative growth of administrative law as a part of public law has taken place. Though it's a different story, Dicey did not agree it as a part of the public law. In fact, he said it is French people who are governed by administrative law, and England knows of no administrative law. But as one of the authors rightly said, he was peeping from foggy England to a sunny France, which was considered to be much more advanced in the term of evolution of the public law. We have developed the concept of separation of power. Montesquieu in France, when he said that there cannot be the combination of all, but then the separation of power was not in the strict sense, it was in the sense of checks and balances. Now, this rule of law is taking so much of dimension. The latest one is, of course, not very old, about 5 years back, it was developed that environmental rule of law. We talked about civil rule of law. Now, the protection of environment, which is so essential to live in a healthy environment. So, the concept of environmental rule of law has been developed, and it has been recognized by the United Nations. This way, when we relate it to the Hindu philosophy, we say our constitution is not a mere set of the fundamental laws that form the basis of governance of our country, but it embodies and reflects certain basic values, philosophy, and objectives that were held very dear to our founding father who drafted our constitution. These values do find expression in various provisions of the Constitution of India, and particularly in the preamble to the Constitution of India. If you study the 4 pillars of the preamble to the Constitution of India, justice, liberty, equality, and fraternity, that is the focus of public law. So the Hindu philosophy is the foundation of justice delivery system from the ancient days to the modern days of the Constitution, which is part of the public law in India, our administrative law, thanks to our judiciary, higher judiciary in particular, they have been applying, and not only applying, evolving the new concepts of public law or new concepts of administrative law to uphold the welfare of the people. So there is very good combination between the public law and the Hindu philosophy. And I'm confident that in this 2-week capacity building program, various learned authors will expound further this concept, and we all will stand game to that. I thank once again the organizer, particularly the director of the Center of Comparative Public Law, for giving me this opportunity to speak in the inaugural session. Thank you very much, sir. My Lord, please accept my greetings. Thank you so much. And pardon me if I have crossed my limits in any way.
Sir, thank you so much for your words of wisdom, sir. And it will be a great pleasure for us to listen you again in our future events, sir. Thank you again, sir. Now, it is both an honor and a privilege to introduce to you our esteemed chief guest, Honorable Mr. Justice V. Ramasubramanian, Judge, Supreme Court of India. Sir was born on 30th June 1958 and hails from Managudi and did his schooling in Hindu High School at Triplicane. Sir completed his degree in Vivekanand College and did his law in Madras Law College. He has enrolled as an advocate in 1983 and was appointed as a judge of the High Court of Judicature of Madras in 2006 and was transferred to Hyderabad High Court in 2016. Justice Ramasubramanian delivered several landmark judgments and has immense contribution to Tamil language. He has authored a book in Tamil on the principles of law and justice in Kamba Ramayana. He wrote a series of articles under the caption Beyond Science in a Tamil newspaper for 27 weeks. He has also added new vocabulary to the language of Tamil by running a column in a Tamil newspaper under the caption Soul with I for 50 weeks. The computerization of the Madras High Court and the subordinate courts in Tamil Nadu gained momentum under his leadership. The selection of the judges to the subordinate judiciary in Tamil Nadu was entrusted to him 3 times from the year 2012. Justice Ramasubramanian was elevated as Chief Justice of High Court of Himachal Pradesh in 2019. And in the same year, he was elevated to Supreme Court of India. Sir is the former Honorable Chancellor of Himachal Pradesh National Law University, Shimla. We welcome you, sir, and I request you to kindly enrich us with your intellectual thoughts. Sir, please.
Thank you, Mr. Gautam. Respected Vice Chancellor of Himachal National Law University, my good friend, Professor Paramjit Jaiswal, Vice Chancellor of SRM University, the Director of the Center of Comparative Public Law, members of the teaching fraternity, dear participants, distinguished invitees. It gives me great pleasure to be part of the inaugural session of the 2-week-long capacity building program on the theme Comparative Public Law and Hindu Philosophy. Actually, I do not know if law and philosophy would go together. While there could be a philosophy behind every law, which we call as the philosophy of law, there need not necessarily be a law of philosophy. While philosophy is generally a speculative pursuit, law is by nature definitive and cannot afford to be speculative. Philosophy is generally for people who care less about the material world, but law regulates the material world. While philosophy focuses more on life hereafter, law is concerned about life here and now. While the object of philosophy is to mold character, the object of law is to ensure proper conduct and behavior. Philosophy aims at making a person a good human being, but law aims at making a person a lawful citizen. Therefore, both law and philosophy converge at a point and also diverge from there. The way philosophers look at law can be easily appreciated from what Alexander Solzhenitsyn, the Russian writer, philosopher, and historian, said in his warning to the West. He said this, I quote, "At the present time, it is widely accepted among lawyers that law is higher than morality. Law is something which is shaped and developed, whereas morality is something inchoate and amorphous. This is not the case. The opposite is true. Morality is higher than law. Law is our human attempt to embody in rules a part of that moral sphere which is above us. We try to understand this morality, bring it down to earth, and present it in the form of law. Sometimes we are successful, sometimes we are not. Sometimes we have a mere caricature of morality, but morality is always higher than law. This view must never be abandoned. I unquote. This is what Alexander Solzhenitsyn said. Therefore, it is good that HNLU is organizing a capacity building program on this theme in association with ICSSR. In fact, the moment I saw the topic, I was reminded of the centenary celebrations of the Madras High Court held in the year 1962. Dr. Sarvapalli Radhakrishnan, one of the greatest philosophers of the 20th century and a role model of a teacher, was the President of India at that time. Therefore, naturally, he was invited to preside over the centenary celebrations of the High Court. On August 6, 1962, Dr. Sarvapalli Radhakrishnan, the President of India and a great philosopher, came and stood before an august gathering of legal luminaries, lawyers, and judges. Describing the predicament of a philosopher to stand in front of judges and lawyers and also address them, Dr. Sarvapalli Radhakrishnan said something in his speech. It goes as follows, I quote, "I am reminded of a passage in Saint Augustine's Confessions. He was addressing a number of theologians, and he wrote there, they have come to listen. You assume they are humble. I have come to talk. People think I am proud, but you, O God, you know how humble I am when I am addressing this gathering of theological experts. When I stand before this array of distinguished judges and lawyers, I feel humbled beyond expression that I should be called upon to speak something upon law." I unquote. This is what a great philosopher said to the lawyers. I do not know if philosophers have had any connection with law except perhaps the law of karma. But I know for certain that lawyers and judges have had connection with philosophy. Immediate reference can be made to a great lawyer, judge, and a jurist of British India by name Sir John George Woodroffe. After being called to the bar by the Inner Temple in 1889, John George Woodroffe was enrolled as an advocate of the Calcutta High Court. He was later made a fellow of the Calcutta University, and appointed as Tagore Law Professor. He was elevated to the bench of the Calcutta High Court in 1904, and he served as a judge of the Calcutta High Court for 18 years. At the time of his retirement, he officiated as the Chief Justice of the Calcutta High Court. This Sir John George Woodroffe had a keen interest in Sanskrit and Hindu philosophy, especially the Mantra Shastra and the Tantra Shastra. He has written a lot of books, including one on Mantra Shastra called The Garland of Letters, and one on Kundalini Shakti under the title The Serpent Power. He was also known by the pseudonym Arthur Avalon. So it appears that law men have been philosophers, though it was not the other way about. Dear friends, historically, all laws, public or private, have been founded across the world only on certain fundamental moral values. Insofar as India is concerned, dharma, which is incapable of being defined in a manner fit for universal application, has been the foundation of all laws, as pointed out by Professor Ishta Jaiswal. The word dharma is derived from the word dhru, which denotes upholding, supporting, nourishing, sustaining. The object of dharma is the maintenance of social order and the stability of society. Chanakya says, law and morality sustain the world. According to Sanatana Dharma, there are 14 branches of learning known as Chaturdasa Vidya. They comprise of 4 Vedas, namely Rig, Yajur, Sama, and Atharva, 6 Angas, Shadangas, namely Siksha, Vyakarana, Chandas, Nirukta, Jyotish, and Kalpa, and 4 Upangas, namely Mimamsa, Nyaya, Puranas, and Dharmashastras. All these 14, 4 Vedas, 6 Angas, and 4 Upangas constitute 14 branches of knowledge. The duties of human beings are mentioned here and there in the Vedas. They are codified in a form and presented in detail in the Dharmashastras. The Dharmashastras are actually called Smritis. But these Smritis have as their source the Vedas, as can be seen from the dictum, Veda Akhila Moolam, Aveda Akhilo Dharma Moolam, Smriti Silecha Tadvidam. Smriti is what is remembered. Interestingly, this Smriti is insanity. Manu observes there is Smriti for the Vedas in the form of notes. The sages who had a profound understanding of the Vedas have brought together the duties and rights, dharma and karma, mentioned in them in the form of notes, and they constitute Smritis. They are written in a language that we can easily understand. They tell you about your duties in details, the do's and don'ts, and how the rites are to be performed. It is of importance to note that 18 great sages by name, Manu, Parasara, Yagyavalkya, Gautama, Harita, Yama, Vishnu, Shanka, Likita, Brihaspati, Daksha, Angirasa, Prachetas, Samvarta, Achanas, Atri, Apastamba, and Satakapa. All these 18 sages mastered the Vedas with their superhuman power and derived smritis from them. These works are known after them, like Manusmriti. The Smriti authored by Manu is Manusmriti. The Smriti by Yajnavalkya is Yajnavalkya Smriti, and so on and so forth. Apart from these 18 Smritis, there are also 18 subsidiary Smritis called Upasmritis. But what is interesting to note is that whatever we find in one Smriti may not be found in another, or may not be found in the same sense in another. There may be differences between one Smriti and another. These differences normally gave rise to doubts. These doubts were sought to be cleared by works called Dharma Shastra Nibandhanas. You may be interested to note that these Nibandhanas are like Article 254 of the Constitution, which speaks about inconsistency and repugnancy between laws and the procedure of reconciling these laws. It appears that each region of our country followed its own Nibandhana. In the north, it is the one authored by Kasinath Upadhyaya. In Maharashtra, it is the Mitakshara. Nirnaya Sindhu by Kamalakara Bhatta is accepted as an authority in Maharashtra also. In the south, what is called Vaidyanatha Dikshitiyam by Vaidyanatha Diksha is being followed. These are the important authorities for the householders. There are also separate Nibandhanas for sannyasis called Vishveshwara Samhita. From what is reflected in these Smritis and the Nibandhanas, the jurisprudence in ancient India could be classified into several distinct topics. They are the recognition of the supremacy of the rule of law, substantive law enumerating the rules relating to marriage, adoption, inheritance, property rights, trade disputes, law of contracts, law governing commercial transactions, etc. Substantive law codifying crimes against persons, properties, and estates, the law relating to the constitution of courts, qualifications and qualities of judges, and the code of ethics for those who are called upon to judge, the civil procedural law dealing with the method of institution of suits, rules of pleadings, recording of evidence, and rendering of judgments, and finally, the criminal procedural law dealing with investigation, collection of evidence, forensic examination, and the punishment of the guilty. Many of you must have known that in a 1977 case, Lord Denning summed up the gist of the principle of the rule of law by quoting Thomas Fuller's famous words, "Be you ever so high, the law is above you." Now please compare this with what Mahabharata says. Shanti Parva in Mahabharata says, the proper functioning of the king is the maintenance of law, not enjoying the luxuries of life. Shanti Parva goes on to say further, it says, law only is supreme. So the king who regulates society in the fulfillment of the law discharges his functions appropriately. In verse 9 of chapter 5, in the Ashramavasika Parva of the Mahabharata, Dhritarashtra tells Yudhishthira as follows: the state can only be preserved by dharma under the rule of law. Please compare this with Thomas Fuller's words. In fact, our ancestors have gone so far as to justify the creation of a system of administration of justice. Brihaspati explains, why do we need courts? Why do we need a system of administration of justice? Brihaspati says this, I quote, in former ages, men were strictly virtuous and devoid of mischievous propensities. Now that avarice and malice have taken possession of men, judicial institutions have become necessary. This is what Brihaspati says. In fact, many of us are blissfully ignorant of the fact that some of the principles of substantive law and the procedural law, which we follow today, were already there in our system. I woke up to this reality when I had a case dealing with the scope and ambit of Section 108 of the Indian Evidence Act 1872. You may be aware of the fact that the Indian Evidence Act 1872 was based upon the framework provided by Sir James Fitzjames Stephen. Section 108 speaks about the burden of proving a person to be alive when he has not been heard of for 7 years. We call this presumption in loose terms as presumption of death. Section 108 reads as follows. Provided that when the question is whether a man is alive or dead, and it is proved that he has not been heard of for 7 years by those who would have naturally heard of him if he had been alive, the burden of proving that he is alive is shifted to the person who affirms it. This is what Section 108 of the Evidence Act says. More often, we used to get cases in high courts of spouses of government servants who go missing and become untraceable for 7 years. If government servants go missing and become untraceable for 7 years, the spouses and the children of those government servants used to make a claim for the terminal benefits of the government servant by invoking this presumption of death under Section 108. But what used to happen in those cases is that during this period of 7 years, the department would have issued notices to him, initiated departmental proceedings, and set him ex parte in the proceedings, and also passed orders of dismissal from service. So whenever such cases came up, the government used to file replies claiming that the man was dismissed from service pursuant to disciplinary proceedings for the misconduct of absconding from service. Invariably, such orders of dismissal used to be passed within 2 or 3 years from the date the man went missing. But the poor spouse and the children who are left in the lurch could naturally come to court only after the expiry of 7 years from the date he went missing. In such cases, taking a sympathetic view, many courts across India were passing orders granting the benefits on the ground that once a period of 7 years had passed and a presumption of death has arisen, the benefit of such presumption should be given from the date the man went missing. Therefore, the order of dismissal passed after the man went missing was of no consequence. This was the view taken by several courts. But there is a problem with the view so taken. A man can be presumed to be dead only after he has become untraceable for 7 years. What Section 108 talks about is only the presumption of death after the expiry of 7 years. Section 108 does not talk about the date of death. There is no presumption as to the date of death, but there is a presumption as to death. That's all. Factum of death. There is a presumption about the factum of death and not a presumption about the date of death. Therefore, when one such case came up before me, when I was a judge of the Hyderabad High Court, I became interested to know as to why this period of 7 years. Why not it be 10 years? Why not it be 14 years? Why not it be 5 years or 4 years? And what is the rationale behind Section 108 fixing the period as 7 years? So I started doing some research. I found something very interesting. The necessity for this rule in the Western world was felt for the first time in England in the 16th century, when sailors went on long voyages by ships from England and their whereabouts were not known for quite some time. The spouses of some of those sailors got married to somebody else. When the sailors returned to England, only to find that their spouses were already married to somebody else, they started filing criminal complaints for bigamy against the wife. Therefore, there was heavy pressure on the king and the parliament, and the parliament enacted what is known as the English Bigamy Act of 1603. It is in section 1 of the English Bigamy Act of 1603 that this rule of 7 years was first introduced. This section says that it will be a defense, valid defense to a charge of bigamy if either of those who were charged marry a second time when the first spouse had been beyond the seas for 7 years, or those whose spouse had been absent for 7 years, although not beyond the seas. Therefore, in the Western world, the origin of this rule could be traced latest to 1603 Bigamy Act. This 7-year rule under the English Bigamy Act was later incorporated in what is called English CCPL Act 1666. It was later adopted in the Life Estates Act 1695 by the Irish Parliament. In Australia, there is no generally applicable legislation for missing persons, but the courts apply the common law presumption of death. Scotland enacted its own law under the title Presumption of Death, Scotland Act 1977, which provides for a declaration of presumed death if a person who is missing has not been known to be alive for a period of at least 7 years. In Ireland, a new law was enacted under the Presumption of Death, Ireland Act 2009, and in England, the Presumption of Death Act 2013 was enacted. Now, why this 7 years? Where from did they get these 7 years? When I started doing research, I found that Indian lawmakers have adopted this presumption at least 1,000 years ago, 1,000 years before the Western lawmakers could even conceive of the same. References to this presumption of death could be found in the Smritis of Manu, Narada, Gautama, and Vasishta. Of course, there are variations in the rules. The number of years that a person should be untraceable differs from one Smriti to another. But the fundamental point is that there is a presumption of death if a person is not heard of for a particular period of time, has found acceptance in Smritis thousands of years ago. In Narada Smriti, chapter 12, under the heading Relations between Men and Women, this is what Narada Smriti says. It is a little controversial, but I am just reproducing. I am not responsible. I am just reproducing what is there in Narada Smriti. It is little casteist, therefore the audience may just take it for what it is. It says, a Brahmana woman should wait for 8 years for a husband who has gone away. But if she has no children, she should wait only 4 years before going to another man. A Kshatriya woman should wait for 6 years, 3 years if she has no children. A Vaishya woman should wait for 4 years if she has children, 2 years if she does not have, and there is no waiting period for the women of the fourth Varna. This is what Narada Smriti says. Today, in an egalitarian society, these distinctions cannot be accepted. We will have to ignore them. But the fundamental principle is that the rule giving rise to a presumption of death was already found in at least 4 of our Smritis, at least 1000 years ago, before the Western world could even imagine of such a principle. Dear friends, apart from the Smritis, all of you know that we can also find some interesting information from Kautilya's Arthashastra. Arthashastra places important aspects of civil law in Book 3 and criminal law in Book 4. Book 4 is completely dedicated to the administration of criminal jurisprudence. Verses 5 and 6 of chapter 8 of Book 4 states that no one shall be arrested for a crime committed more than 3 nights earlier unless he is caught with the tools of the crime. Look at this rule, how important this rule is. Today, in most of the criminal cases, one of the defenses taken by defense lawyers and many times accepted by courts is that the FIR was filed belatedly, giving rise to a suspicion. Because things change, evidence is tampered with. Therefore, whenever an FIR is lodged, several days later, it is looked down with suspicion. Kautilya incorporates this rule in verses 5 and 6 when he says, no one shall be arrested for a crime committed more than 3 nights earlier unless he is caught with the tools of the crime. And he also explains that this is because of the difficulties of conducting a proper investigation if the offense is detected after some time. In fact, chapter 7 of Book 4 of Kautilya's Arthashastra deals with post-mortem examination in detail. Kautilya states that magistrate shall conduct a post-mortem on any case of sudden unnatural death after smearing the body with oil to bring out bruises, swellings, and other injuries. He says that that examination on the cause of death should be conducted even in cases where it appears that the person had committed suicide by hanging, because sometimes for fear of punishment, marks are produced on the throat of the body after the murder. This is what Kautilya says in his Arthashastra. Kautilya classifies the cause of death into 3, namely 1, stopping of breath by strangulating, hanging, asphyxiation or drowning. Number 2, by physical injury, by beating or throwing from height. And number 3, by poisoning. In fact, the rules of forensic evidence are very elaborately given by Kautilya. The manner in which a criminal investigation should be conducted is also detailed by him He says, I quote from Kautilya, those closely associated with the victim of the murder shall be questioned about whether the crime could have been committed by agents of the deceased, by thieves for the sake of money, or by enemies of someone else due to mistaken identity. They shall also be questioned about who summoned the deceased, who went with him, last seen theory, with whom he stayed, and who took him to the scene of the crime. Those who were near the scene of the crime shall be questioned individually about who brought the deceased to that place and whether they had seen anyone behaving suspiciously. Kautilya also prescribes an elaborate system of penalties, including capital punishment with or without torture. This is why Arthashastra is also called Dandaniti. Dear friends, please remember that we are living in the second most populous country of the world, occupying a landmass of just 2.4% of the world's total landmass. The diversity in our country is too huge, with people following 8 different religions, at least 8 major religions. We are comprised of 1,686 ethnic groups. We speak 1,652 languages and dialects, and we are divided by 3,800 castes and communities. But all of us speak in one voice. That is because of the great heritage that we have actually inherited. Please look at the contribution that our country, our ancestors have made to the growth and the development of human civilization. It is acknowledged that zero was invented by Aryabhatta. The world's first university was established in Takshila. The University of Nalanda was built in the 4th century BC. The value of pi, 22/7, was first calculated by Bodhayana, who explained the concept of what later was found out to be Pythagorean. Quadratic equations were conceived by Sridharacharya in the 11th century, when many cultures were nomadic forest dwellers. Albert Einstein, the greatest scientist of the 20th century, said, I quote, we owe a lot to the Indians who taught us how to count, without which no worthwhile scientific discovery could have been made. I unquote. Mark Twain, who was known to be a maverick, he said this about India, I quote, India is the cradle of the human race, the birthplace of human speech, the mother of history, the grandmother of legend, and the great-grandmother of tradition. Our most valuable and most destructive materials in the history of man are treasured up in India only. Lin Yutang, the Chinese traveler who wrote that very famous book called Wisdom of India, he said this, I quote, India was China's teacher in religion and imaginative literature, and the world's teacher in trigonometry, quadratic equations, grammar, phonetics, Arabian Nights, animal fables, chess, as well as in philosophy. India inspired Goethe, Herder, Emerson, Schopenhauer, and perhaps Aesop. This is what Lin Yutang had to say. Therefore, with this kind of a background, we should be proud of our heritage. And it is in that context that this capacity building program on the theme comparative public law and Hindu philosophy, or perhaps the Indian philosophy, or perhaps the Indian philosophy of law, which would have been a more ideal topic, is befitting. And I wish HPNLU, HNLU, the Center for Comparative Public Law, ICSSR, and its participants a wonderful, very educative program ahead. Thank you very much.
So much. Thank you so much, Your Lordship. I'm sure these thought-provoking words have given the participants a lot of points to ponder and for the center to further research on. Thank you once again. Now, dear all, we all know that this gratitude creates the most wonderful feeling. It can strengthen friendship and makes us better human beings. So now I request Professor S.S. Jaswal, Registrar, Himachal Pradesh National Law University, Shimla, to kindly propose a hearty vote of thanks. Sir, please.
Thank you, Dr. Deepika. Honorable Chief Justice V. Ramasubramanian, Judge, Supreme Court of India, Professor Paramjit Singh Jaswal, Honorable Vice Chancellor, SR University, New Delhi, NCR, Sonipat, Haryana, Professor Nishta Jaswal, Honorable Vice Chancellor, HPNLU, Shimla, Dr. Chanchal Singh, Director of Comparative Public Law Center, Himachal Pradesh National University, Shimla, all the participants connected with us virtually for the inaugural session of 2-week online capacity building program on comparative public law and Hindu philosophy, research and teaching dimensions in 21st century India, being organized by Center for Comparative Public Law, Himachal Pradesh National University, Shimla, in association with Indian Council of Social Science Research, New Delhi. We are obliged and thankful to our chief guest, Honorable Shri Justice V. Subramanian, Judge, Supreme Court of India, for sparing his valuable time for the inaugural session of this program. Sir, we take this opportunity to thank you for accepting our invitation, sharing your experience and knowledge. Thank you, Lordship, for setting tone for coming session of this program. Thank you, Lordship. We are also thankful to our chief guest of today's program, Professor Paramjit Singh Jaswal, Honorable Vice Chancellor, SRM University, for taking time out of his busy schedule and gracing the occasion. Sir, your words of wisdom, inspiration, and motivation will go a long way for participants of this program. Thank you, sir. We are thankful to our Honorable Vice Chancellor, Professor Nishta Jaswal, for taking lead for organizing this capacity building program. Thank you, ma'am, for leading from the front and for your guidance, motivation, and encouragement. Thank you, ma'am. Our thanks are due to all the participants, Dr. Chanchal Singh, co-director of this program, Mr. Ayush Raj, both of them are working very hard for making this program a big success. All the teaching and non-teaching staff of this university, as well as the teaching staff, technical staff, for their cooperation. Thank you one and all for your patience, hearing, and sparing your valuable time. We are looking forward for the coming sessions, and we are sure that this will be one of the best programs in your career we are going to organize for you. Thank you one and all, please. Thank you.
Thank you, Lordship. We are mesmerized. Thank you so much.
Now, with the permission of the Honorable Chief Guest, Guest of Honor, and our Honorable Vice Chancellor, may we conclude the inaugural session of the two-week capacity building program.
Yes. Yes. Thank you.
Thank you once again.
Thank you.
Thank you, Lordship.
Thank you, Lordship. Thank you very much.
Can I take leave?
Sir,
Yes.
please.
Give your blessing, Lordship. Give you a blessing, Lord. Thank you.
Participants, you are requested to stay for another 5 minutes for further discussion with the director, Dr. Chanchal. Please.
I would like to invite any question you have regarding the conduct of this program for next 2 weeks. I hope you all have received the reading material the Center for Comparative Public Law has prepared for this program. Have you all received soft copy?
Yes, for me it's done.
Thank you. Any query regarding the process, joining, and anything else?
Good evening, Professor.
Sir.
Am I audible, sir?
Yes, perfectly.
Sir, the only thing with me is that I would not be able to apply the virtual background that you have given to me. Please pardon
No
for
issue.
that particular. Thank you.
Those who are not able to do it, there is no issue. That is only a decorative thing that this topic appears. Our purpose, the problem for all of us is, and as Honorable Justice suggested, that the topic would have been reframed in a better manner. But these are debatable points. Our purpose simply is to learn from each other, whatever best or whoever best speakers, resource persons are available in India. We have tried to get them. One of the resource person we have just seen. Our purpose, our plan after this program is to transcribe all these lectures, get in touch with each resource person. A kind of first elementary reading material might be published in a form of book. Another point, for the purpose that none of us are trained in this tradition. This is our greatest handicap. None of us, very few of us know Sanskrit or have read literatures of the kind we are going to be aware of or be at least familiar in next 2 weeks. So this is the main idea behind this week's program project. Another important point that it is mandatory for all participants to join in time or 5 minutes before the session starts and continue till the end of the session, particular sessions. If because we are bound by ICSSR rules, as well as we have to be sincere about the program. So it's not about only certificates that our intention is. The second important point that you all have to go through the 400 pages sort of reading material prepared. There may be 2 tests. One is scheduled. One more test or exercise might be scheduled based on essentially on those reading materials. So we have to qualify that tests before we conclude this after 2 weeks. This comparative this CBP. Any query?
Sir, I wanted to ask one question regarding the test.
Yes, please.
Sir, I mean, what would be the pattern of the test?
We are still in the process. Objective types, maybe there are some fables or anecdotes from Indian literature or sciences you must have heard. What moral learning we can draw from those stories. So it can be anything based on our analytical abilities. But be aware that most of the questions will come from our some of the reading materials. 400 pages are not too big for 2 weeks for any scholar or professor. Second, questions may also be based, will be based on teachings of resource persons we have attended the sessions.
Okay, sir. Thank you.
So can we conclude this session? Thank you. Thanking everyone. Now we will meet again on Monday, 9:50 sharp. Same link will continue for all sessions. Thank you.
Thank you. Bye-bye.
Thank you, everyone.
Thank you, sir.